All right, good afternoon, everyone. So, today we'll be starting with a new act that is the Rajasthan Court Fees and Suit Valuation Act 1961. Now, if we talk about this particular act, this is another new act which is added in our Rajasthan Judicial Service examination this year. So this act has certain sections, certain chapter, and certain parts, which is very, very important from our exam perspective. Why? Because even though when this act was not in our exam, we used to get certain questions from this act. Okay, there were certain questions from this act जो हमारे act exam में नहीं था तब भी आया करते थे. So now it is already added in our syllabus. So you definitely can expect 2 to 3 questions in your prelims and like 1 or 2 questions in your mains. So in prelims, it carries a weightage of 2 to 3 marks, but for the mains perspective, it carries a weightage like it varies. Okay, it can be 4, 5, 6, whatever it is. Right now, basically, what this act is all about, the Rajasthan Court Fees and Suit Valuation Act. Okay, what this act is all about. So see, it is Court Fees and Suit Valuations Act. Okay, so whenever you are starting a proceeding before a court, okay, you need to file a suit for starting a proceeding before the court. So whenever you are starting a proceeding by filing a suit, आप ऐसे ही फाइल नहीं कर सकते. फॉर फाइलिंग द सूट यू हैव टू पे कोर्ट फीस टू द कोर्ट. ओके, बिकॉज कोर्ट इज गोइंग टू एंटरटेन योर प्ली. ओके, कोर्ट आपको एक रिलीफ देने वाला है. सो फॉर दैट रिलीफ यू हैव टू पे सर्टेन फीस टू द कोर्ट. ओके, ऐसा नहीं है कि लाइक सी कोर्ट इज वर्किंग राइट. कोर्ट हैव टू पे salaries to everyone and so on. So basically court is not going to entertain your plea for free. Okay, you have to pay certain fees to the court, and the amount of that fee is decided by this Rajasthan Court Fees and Suit Valuation Act. That if this is a particular type of suit, what will be the court fee? If this is a type of suit, what will be the court fee? Okay, कितना court fees आपको देना है, तो वो सारा इस act से decide होगा. Then next thing, the act number, that is Act number 23 of 1961. It is Act number 23 of 1961. Then comes the enactment date. Okay, which is already written here, 26th day of August 1961. This is the enactment date of the act. 26th August 1961. This question you can expect in your exam. Then comes the enforcement date. Okay, enforcement date of this act. So you can write down, it is 1st of November 1961. Okay, the enforcement date is 1st of November 1961. Now, another very important question. This is an exhaustive act. Okay, court fees, suit valuations को लेके ये एक exhaustive act है. How you got to know that? By the word consolidate. The word consolidate is written here, which shows that it's an exhaustive act. Okay, it's an act to amend and consolidate the laws relating to court fees. What does the word consolidate means? तो consolidate का मतलब होता है collect. Okay, so it's an act which collect all the laws relating to court fees. So wherever in any preamble, if you see the word consolidate, just understand that means it's an exhaustive thing. Okay, this rule, this statute, this act is exhaustive if you see the word consolidate. So because in this act the word consolidate is here, so we can presume that this is an exhaustive act. Okay, now an act to amend and consolidate the law relating to court fee and valuation of suit. Not only the court fee but also with regard to valuation of suit. Now, what is difference between these two words, court fees and suit valuation? In दोनों में क्या difference है? See, court fees is simple. If you have this suit, this is your court fee. Okay, अगर आपको relief का suit file करना है तो आपको इतनी court fee देनी होगी. But then what is valuation of suits? So valuation of suits means valuation of amount of suit. For example, you're filing a suit for land. Okay, recovery of land. आप एक suit file कर रहे हो. तो उस लैंड की क्या वैल्यू होगी? ओके, द अमाउंट ऑफ दैट लैंड, उस मार्केट वैल्यू ऑफ दैट लैंड विल बी कंसिडर्ड एज सूट वैल्यूएशन कि इस सूट की ये वैल्यू है. बिकॉज सी, if you remember, we have 3 types of jurisdiction in CPC. There are 3 types of jurisdiction. What are those? Pecuniary jurisdiction, territorial jurisdiction, and subject matter jurisdiction. Right? There are 3 types of jurisdiction: pecuniary, territorial, and subject matter jurisdiction. When it is territorial jurisdiction, then where the subject matter is situated, okay, the court having jurisdiction in that territory will be entertaining the suit. If it is subject matter jurisdiction, that means अगर divorce का case है तो family court में जाओ, right? अगर land का case है which is paying revenue तो आप revenue court में जाओ. अगर कोई दूसरे लैंड का केस है तो आप सिविल कोर्ट में जाओ. तो बेसिकली वो सब्जेक्ट मैटर जुरिस्डिक्शन होता है. Then comes pecuniary jurisdiction. Now, what is pecuniary jurisdiction? If the amount value of your suit is 1 lakh, then you have to approach civil judge court. If it is more than 2 lakh, then approach senior civil judge. If it is more than 5 lakh, then approach to district judge court. तो accordingly pecuniary value के आप कोर्ट अपना डिसाइड करते हैं. तो when we decide the valuation of suit, it helps in deciding the pecuniary jurisdiction of the court. Okay, so this is very important, that why we need to value the suit. Okay, why we need to count the valuation of a suit, because it is going to help us in deciding the pecuniary jurisdiction. अगर हम एक सूट की वैल्यू डिसाइड कर देते हैं तो वो इन द एंड हमें हेल्प करता है कि ओके सो दिस इज द वैल्यू ऑफ द सूट, नाउ विच कोर्ट विल बी हैविंग जुरिस्डिक्शन. पेक्यूनरी जुरिस्डिक्शन को एंटरटेन करने के लिए सूट वैल्यूएशन हमें हेल्प करता है. एंड समटाइम्स by that suit valuation we get to know our court fees also. Okay, that okay, this is the value of suit, then this will be your court fee. Let's take an example. If 5,000 is the value of your suit, then 5 rupees will be the court fee. Okay, so these are the words court fees and valuation of suit and how they are interlinked with each other. But this is specifically with the state of Rajasthan only. Okay, this is not for any other state. This act is applicable only on state of Rajasthan. Then how many sections are there in this act? So in total there are 74 sections in this act. Okay, in total there are 74 sections in this act. How many chapters are there? So there are 8 chapters. All right, then how many schedules are there? So there are 3 schedules. There are 3 schedules in this act. Okay, what are these schedules for? ये schedule हमें क्या बताता है? So schedule 1 talks about ad valorem fee. Ad valorem fee. Ad valorem fee means according to the value of property, they will decide the fee. Okay. Then schedule second, that is fixed fee. There are certain cases, okay, there are certain types of suits for which the value is fixed. उनकी fees जो है वो fix हो रखी है. तो that is given in schedule 2. Schedule 1 हमें बताता है कि आप वैल्यू के अकॉर्डिंग क्या फीस रहेगी. 5,000 is value, then what will be the fee? So that is schedule 1. Schedule 2 provides that there are fixed type of reliefs for which this is the fee. So that is in schedule 2. Then comes schedule 3. Schedule 3 provides us forms. Okay, that ये जो fees होगा इनका form क्या होगा? So that is what there in schedule 3. All right, I hope everything is clear so far. If there is any doubt, you can write down in the chat box, or then we'll proceed with the chapter 1. Any doubt, guys? So far, everything is clear? Okay, all right. Then let's move on to the next thing. That is chapter 1, preliminary. Now, chapter 1 talks about, like any other act, short title, extent, commencement, and definition, and the application of this act. So, short title, extent, commencement is very sorted thing. Short title क्या होता है? Rajasthan Court Fees and Suit Valuation Act 1961. Extent, it extend to state of Rajasthan. Okay, whole of India मत कर देना एग्जाम में जल्दी में, because it is not applicable to whole of India. Okay, it is only applicable to state of Rajasthan. Then कब enforce होगा? तो enforcement date हमने already देख ली है, 1st November 1961. Okay, now see, there is thing written, it shall come into force on such date as state government may by notification in official gazette appoint. Okay, तो exam में अगर ये question आ जाए तो don't do central government here. Okay, because it's a state oriented act, so the correct answer will be state government will decide that. Then moving on to the next thing, application of this act. Okay, so कहाँ ये act applicable होगा, and this is a thing which is very very important from your exam perspective, a very important thing. Okay, this is very important provision from your exam perspective. So where this act is going to be applied. So the provision of this act shall not apply. कहाँ apply नहीं होगा? They are talking about where it will not be applied. So it shall not apply to documents presented or to be presented before an officer serving under the central government. Okay, so if any document is presented, okay, yeah, presented before the officer of central government, or it is presented by the officer of central government. Okay, उनके सामने भी आप कर रहे हो या वो खुद ही कर रहे हैं. In both these two cases, this chapter will not have any application, or this act will not have any application. Okay, first thing. Second thing, if there is any other special or local law, okay, any other special or local law is there which is providing its own fees. Okay, for example, the ideal example for this is Rajasthan Rent Control Act. If we see section 28 of Rajasthan Rent Control Act, there is already provided court fees. Okay, that अगर revision का suit होगा तो this is the court fee. अगर like eviction का suit होगा तो this is the court fee. So they have specifically provided the court fee. So this subsection 2 says that if there is any other law which contain its own court fees, okay, जिसमें अपनी खुद की court fees दे रखी है, then this act is not going to have override effect of that law. Okay, because this is a general law. This is a general law with regard to suit and court fees evaluation act. So that is the reason if there is any other special or local law which is prescribing its own court fee, ये act उस पे applicability नहीं रखेगा, override effect नहीं करेगा. Because in case of conflict between general law and special law, always the special law will prevail. Okay, so this is subsection 2, that where this act will not apply. So this will not apply to any document presented by or before central government, officer of central government. Second, this is not going to be applied where there is already a specific court fee provided in any other law. Moving on to section 2, that is definitions. Now in this act, unless the subject or context otherwise required, appeal includes a cross objection. Okay, the word appeal includes cross objection. Now what is cross objection, where it is given? So it is given in order 41, rule 22 of CPC. Okay, you can just write it next to here. The concept of cross objection. It is given in order 41, rule 22 of CPC. What is cross objection? Cross objection क्या होता है? Okay, is there anyone who can tell me the meaning of cross objection? Anyone? No one. All right. See, what is cross objection? I'll tell you. So suppose there are two persons A and B. Okay, there are two persons A and B. A have claimed two reliefs, relief X and Y. B has also claimed two relief Z and A. Okay, B ने भी दो reliefs claim की है अपने like set of thing में. Now suppose A has lost the thing. Okay, a decree is passed against A for which A has appealed. A ने उसमें appeal कर दी. Okay, now this B in the same appeal has put out his objections also. उसने ये जो claims है ये भी इस appeal में अपने रख दी है, and that is what called as cross objections. Okay, so a party who is already objecting in appeal, the other party is objecting in the same appeal. That is called as cross objections. Okay, so this cross objection will also be treated as appeal for the purpose of this act. Now what is court? So court, civil court तो होता ही है, okay, but court is not restricted to civil courts only. Okay, here court is not only restricted to civil courts, but court also includes, what includes? Civil courts, revenue courts, criminal courts, and includes a tribunal or other authority having jurisdiction to decide question affecting the rights of parties. Okay, so here court means tribunals also. Okay, civil court तो होते ही है, उनके revenue court भी होंगे, criminal courts are also there. Okay, this act is not only providing us a court fee for civil courts but also for criminal courts. So civil courts, revenue courts, criminal court, this is very important term, criminal court, because generally हम सोचते हैं कि civil court ही होगा because the word suit is used here. Okay, but suit से पहले court fees word भी use है. Okay, so that is why criminal courts are also included here, and also any tribunal or other authority which decides the right of a parties. ऐसे कोई भी अथॉरिटी जो पार्टीज के राइट्स को डिसाइड करती है, उसके सामने आपको क्या फीस देनी है टू प्रेजेंट योर प्ली, दैट इज आल्सो डिसाइडेड अंडर दिस एक्ट. Okay, this is very very important definition, court. Then prescribed means prescribed by rules made under this act. Now again this is important. Okay, this subsection 4. It says that any expression which is used in this act, okay, any expression which is used in this संहिता and but not defined here. Okay, ऐसा कोई भी expression जो इस संहिता में यूज किया गया but define नहीं किया गया, इस एक्ट में यूज किया गया है but define नहीं किया गया है, ना तो इस एक्ट में डिफाइन किया गया है, ना राजस्थान जनरल क्लॉज एक्ट में डिफाइन किया है. ओके, ना तो वो इस एक्ट में डिफाइंड है, ना ही वो जनरल क्लॉज एक्ट में डिफाइंड है. तो हम उसकी मीनिंग कहां से लेंगे? फ्रॉम वेयर वी विल टेक द मीनिंग ऑफ दिस पर्टिकुलर वर्ड? तो वी विल टेक द मीनिंग ऑफ दैट वर्ड फ्रॉम सीपीसी इफ इट इज डिफाइंड देयर. ओके, सो बट डिफाइंड इन सीपीसी shall have the same meaning. And this is your important question from exam perspective, that any word which is not defined in this act and na hi wo Rajasthan General Laws Act mein defined hai, okay, but is defined in CPC, then we will take its meaning from CPC. I hope all these four definitions are clear to everyone. Moving on to the next thing, that is chapter 2. Now liability to pay fee. Okay, so who all will be having liability to pay fee? किस किस को फीस पे करना ही पड़ेगा? Okay, So it says levy of fee in courts and public offices. No document which is chargeable with fee under this act shall be filed, exhibited, recorded, or acted or furnished by any court including the High Court. ऐसा कोई भी डॉक्यूमेंट जिस पे इस एक्ट के अंदर एक कोर्ट फी चार्ज की गई है, any such document on which a court fee is charged under this act, okay, cannot be filed, exhibited or recorded or acted or furnished. आप उसको ना फाइल कर सकते हो, ना एग्जिबिट कर सकते हो, ना रिकॉर्ड कर सकते हो, ना ही उस पे एक्ट कर सकते हो, और ना ही उसे कहीं फर्निश कर सकते हो इन एनी कोर्ट including the high court also. And this is again very important thing. Okay, what you cannot do with a document for which a fee is charged but you are not paying it. So neither you can file it, nor you can exhibit, nor you can record, nor you can act upon it, nor you can furnish. In which court? In any court, even if including high court. Okay, high court bhi isme included hai. All right, high court is also included here. Then, and also apart from that, it will not be filed, exhibited, recorded or acted or furnished by any public officer also. Okay, ना तो कोर्ट उसको इस पे सारे कुछ एक्शंस ले सकता है, ना ही कोई पब्लिक ऑफिसर इस पे कुछ एक्शंस ले सकता है. So no one can take any actions with regard to these documents unless in respect of such document there be a fee that is paid. Okay, so this is very clear which we have already read कि जब तक आप उस फी को पे नहीं कर देते हैं, आप उस डॉक्यूमेंट को फाइल, एग्जिबिट, रिकॉर्ड, एक्ट, फर्निश नहीं कर सकते हो. ओके, ना तो कोई पब्लिक ऑफिस कर सकता है, ना कोई पब्लिक ऑफिसर कर सकता है, ना ही कोई कोर्ट कर सकता है इंक्लूडिंग द हाई कोर्ट. Provided whenever the filing or exhibition in a criminal court. Okay, now this is again a very important thing. You can expect a question from provided. Provided says that suppose we have read no that court includes criminal court also. So suppose you have to pay a court fee in the criminal court. Okay, you have to pay a court fee in criminal court and you're not paying it. तो क्या क्रिमिनल कोर्ट भी उस डॉक्यूमेंट को एंटरटेन नहीं करेगा? सो द आंसर इज नो. ओके, द आंसर इज नो. इफ इन द ओपिनियन ऑफ कोर्ट not entertaining the document, okay, will amount to miscarriage of justice or failure of justice. अगर criminal court को लगता है, because see, in civil courts, in civil suits, generally individual parties' rights are affected, but in case of criminal matter, public at large is getting affected, right? Because it's a prosecution for public at large. It's an offense against public at large. So criminal में generally public at large is getting affected. तो अगर कोर्ट को लगता है कि बिकॉज ऑफ नॉट एंटरटेनिंग दिस थिंग, जस्ट बिकॉज ऑफ कोर्ट फी, इफ पब्लिक एट लार्ज विल बी अफेक्टेड और अ फेलियर ऑफ जस्टिस विल बी देयर, ओके, इससे फेलियर ऑफ जस्टिस हो जाएगा, तो कोर्ट कैन सिंपली प्रोहिबिट सच फी. कोर्ट उसको मना कर सकता है कि ठीक है, इट्स ओके, इवन इफ यू आर नॉट पेइंग फी, वी विल एंटरटेन इट, बट एट द लेटर स्टेज द पर्सन हैव टू पे इट. ओके, ऐसा नहीं है कि मना मतलब कंप्लीटली मना, नो. एट लेटर स्टेज कोर्ट कैन आस्क फॉर द फी, या फिर फाइनली जब भी फाइन वगैरह कर रहे हैं तो उस फी को वहां से सेट आउट कर देंगे. सो दिस इज हाउ थिंग्स वर्क इन क्रिमिनल कोर्ट्स. Okay, so this is all about section 4. I hope this is clear. Next is fee on documents inadvertently received. Okay, so now let's read it. When a document on which the whole or any part of fee prescribed as by this act has not been paid is produced or has through mistake or inadvertence been received in any court or public office, the court or the head of the office may at its discretion allow the person by whom such fee is payable to pay the fee. Okay, so suppose आपने कोई डॉक्यूमेंट कोर्ट में सबमिट किया, आपने कोई प्लेंट सबमिट करी जिसपे एक पर्टिकुलर अमाउंट ऑफ फी थे, दैट इज 5,000 फॉर एग्जाम्पल. ओके, बट यू हैव पेड either only 2,500 or you have not paid at all. Okay, but the person has received the document inadvertently, by mistakenly. Okay, mistakenly उन्होंने डॉक्यूमेंट को रिसीव कर दिया है. Alright, mistakenly they have accepted the document. In that case, at the later stage, the head of the court. Okay, see the court. These are the two persons. Okay, the court or head of the office. Okay, these two person can later on tell the person, allow the person to pay the fee. Jitna bhi remaining hai, you just pay it within the time that is fixed by the person. Okay, and if the person has paid the fee within that time, then it will have the same effect as it is paid at the first instance. Okay, so yeah, आपको ये दो चीज ध्यान रखनी है, कौन सी पर्सन्स को अथॉरिटी है कि उसको एक्सेप्ट कर ले और एक टाइम प्रेस्क्राइब कर दे. सो दैट इज ईदर कोर्ट और द हेड ऑफ द ऑफिस. ओके, Now, why they have used the word head of the office? Because in earlier section 4, we have read no that even a public office cannot exhibit the same thing. ना तो कोर्ट कर सकता है और ना ही कोई पब्लिक ऑफिस कर सकता है. So अगर पब्लिक ऑफिस भी कर लेता है तो उसका जो हेड होगा वो उसको टाइम दे सकता है. Okay, that is section 5. Now comes multifarious suits. Okay, so what is multifarious suits? Multifarious suits मतलब आप एक ही सूट में different reliefs मांग रहे हो. Okay, you are claiming different reliefs in one suit. That is, if we talk about CPC, it is in order to rule 2. Order to rule 2 of CPC. Okay, cause of actions. तो एक ही cause of action के लिए आप different reliefs claim कर रहे हो. All right. Then in that case, what will happen? So if you are, suppose you are claiming 3 reliefs, relief 1, relief 2, and relief 3 for a particular cause of action. In that case, what court fee you will pay? So you will pay a aggregate of all the reliefs. Okay. So 1, 2, 3 तीनों का aggregate आप pay कर दोगे. So in any suit in which separate and distinct reliefs are sought on the same cause of action, one cause of action, multiple reliefs. The fees will be aggregate of all the relief. Aggregate means total of all the reliefs. Okay, aggregate value of the reliefs. Provided that if the relief is sought only as ancillary to the main relief, the plaintiff shall be chargeable only for the value of main relief. So if it's just the ancillary of main, ancillary means extended provision of main. Okay, main का अगर वो सिर्फ ancillary relief, extended provision है कि either this or this. Okay, in that case ओनली वन का आपको मेन का जो मेन रिलीफ है उसका आपको चार्जेबल करना है. फॉर एग्जाम्पल अगर हम स्पेसिफिक रिलीफ एक्ट में देखते हैं, ओके, सो वी जनरली क्लेम ईदर गिव अस स्पेसिफिक परफॉर्मेंस और यू गिव अस द कॉम्पनसेशन. ओके, तो हम दोनों का रिलीफ नहीं बताएंगे क्योंकि मेन रिलीफ क्या है? मेन रिलीफ है स्पेसिफिक परफॉर्मेंस. सो यू विल add the court fee only for specific performance and not for the compensation because it's just ancillary to the main relief. Then where more reliefs than one based on the same cause of action are sought in the alternative suit. Okay, where more relief than one based on same cause of action are sought in alternative in any suit, the plaintiff shall be charged with the highest value of fee leviable on the relief. So suppose you are in one suit, in one cause of action, you are asking for alternative reliefs. Okay, alternative मतलब या तो ये या ये दे दो. Okay, या तो आप X दे दो या Y relief दे दो. उस केस में जिसकी फीस हाईएस्ट होगी, okay, the relief which is having highest fee, that will be given to the person. Okay, that shall be chargeable on the person. So just read this thing. See, this question is very important from exam perspective. Okay, multifarious suits. पहला कहता है एक ही cause of action पे multiple reliefs आप claim कर रहे हो. In that case, the adequate of all or aggregate of all. Second is one cause of action, either this or this, alternative relief. तो उसमें जो highest value होगी आप उसको relief का charge कर दोगे. And third, where a suit embraces two or more distinct and different cause of action. In one suit, there are two and more different cause of action. And उसके लिए आप separate reliefs मांग रहे हो. Okay, there are two cause of action and for which you are claiming separate reliefs. Then either alternatively or cumulatively, the plaintiff shall be chargeable with the aggregate amount of the fees with which plaintiff would be chargeable under the act if separate suit were instituted. So it's simple. Okay, सपोज अगर दोनों कॉज ऑफ एक्शन के लिए आप सेपरेट सूट फाइल करते, इफ फॉर बोथ कॉज ऑफ एक्शन यू हैव फाइल्ड सेपरेट सूट्स, ओके, तो जो एक्स सूट एंड वाई सूट, तो उनकी जो फीस होगी उनका आपको एग्रीगेट चार्ज कर देना. दैट्स इट. ओके, इट्स लाइक नॉट दैट much. It's simple ki if it is separate, let's just consider it as separate suit when there are two cause of action and the aggregate of that value will be chargeable. Now, where the cause of action in respect of reliefs claimed alternatively against the same person arise out of the same transaction. अगर आप alternatively कर रहे हो, okay, like against the same person and for same transaction, like X is claiming a relief against Y for one cause of action only. Okay, one cause of action is there between X and Y and X is claiming a relief against Y and that is alternative relief कि या तो मुझे Y के against ये relief दे दो या ये relief दे दो. Okay, या तो आप उसको कॉन्ट्रैक्ट को परफॉर्म करवा दो या फिर आप मुझे उस कॉन्ट्रैक्ट को खत्म ही करवा दो. अब अगर अल्टरनेट रिलीफ मांग रहे हो उस केस में क्या होगा? देन plaintiff shall be chargeable only with the highest of fee chargeable on them. So this thing we have already read कि when there are alternative reliefs, then which one is highest, that will be chargeable. Okay. Next, nothing in subsection 3 shall be deemed to affect any order power conferred under Order 6 Rule 2 of CPC. So Order 2 Rule 6 of CPC में कोई भी ऐसी चीज है तो ये section का subsection 3 is not going to affect that. The provision of this section shall apply mutatis mutandis to memorandum of appeals, application, petition, and written statement. So mutatis mutandis means as same as here. Okay, same. It means same. So whatever provisions of this section are, वो appeals, application, petition और written statement में भी इसी तरीके से apply किए जाएंगे. Okay. Now this is explanation is again very important. Explanation says a suit for possession of immovable property and for mesne profit. Okay. इन दोनों का जो सूट है for the possession of immovable property and mesne profit, they shall be deemed to be based on the same cause of action. Okay, माना जाएगा कि ये जो सूट्स है ये सेम कॉज ऑफ एक्शन पे बेस्ड, दे आर बेस्ड ऑन सेम cause of action. Then section 7, that is determination of market value. Okay. Now generally court fee is equal to market value or 5% of market value, 10% of market value. Now how will you determine the market value of property? आप कैसे determine करोगे कि इस property की market value क्या है? So it says where the fee payable under this act depends on the market value of any property. Such value shall be determined as on the date of presentation of plaint. A very, very important thing from your exam perspective. Market value will be determined on which date? कौन सी date की market value आपको determine करनी है? So it will be determined on the date of presentation of plaint. The day you are presenting your plaint, at that day, whatever the market value is, that will be the market value of any property. Okay, just underline this, on the day of presentation of plaint. Second, the market value of land in suits falling under clause A and B of section 24 or 26 or 28, so these are certain sections, shall be deemed to be. So if the land which is falling under these sections, okay, तो उसकी market value हम कैसे determine करेंगे? So where rent in respect of such land has been settled, अगर उसकी rent settle हो चुकी है, rent settle means the rent is decided that for this property 1000 is the rent or for this property 5000 is the rent. If rent is decided for that property, then 25 times the rent sanctioned thereof during the last settlement. तो जो भी rent उन्होंने decide की है उसका 25 times will be the market value. And where no rent is settled, अगर कोई rent settle नहीं किया है, so 25 times the rent sanctioned during the last settlement for similar land is the neighborhood. तो उस neighborhood में जो similar land है उसकी जो rent settle हो रखी है, okay, 25 times of that rent. All right, I hope this is clear. Right? If property is falling under certain sections, in that case, the market value of that property will be, if the rent is settled, then 25 times of that rent. If no rent is settled, then जो उसके neighborhood में settled rent के lands है, उन land की 25 times. Then comes set off or counterclaim. For the purpose of set off and counterclaim, what shall be the fee? So a written statement pleading a set off or counterclaim shall be chargeable with the fee in same manner as a plaint. तो जैसे हम प्लेंट पे एक कोर्ट फी लगाते हैं, वैसे ही अगर एक रिटन स्टेटमेंट में आप सेट ऑफ और काउंटर क्लेम प्ली कर रहे हो तो उसमें भी एक कोर्ट फी चार्जेबल होगी. ओके, देयर आल्सो कोर्ट फी विल बी चार्जेबल. Then documents falling under two or more description. When a document is falling under two or more description of this act, like X में भी fall कर रहा है, Y में भी fall कर रहा है, then what will be the court fee? Okay. So where a document is falling under two or more description, and for that the court fee is also different. Okay. Where the fees chargeable are also different. Be chargeable only with the highest value of such fee. So दोनों में से जो highest value होगी, that will be charged on the person. Okay, so if one document is falling under two different descriptions, एक ही document दो descriptions में fall कर रहा है and दोनों के लिए अलग-अलग court fees है. If similar court fees there, then it's well and good. आप कोई भी लगा दो. Okay, but if there is different court fee, then which is the highest one, that will be chargeable on the person. Where one of such description is special and other one is general, then fee will be chargeable as per special description. Now, so, as we have already read this thing, that when there is something special and something general, special will always prevail. So, अगर वो जो description है जिसमें एक ही document fall कर रहा है, when one document is falling within two descriptions, one description is special, one description is general, the court fee will be chargeable for the special description and not for the general one. All right, so this was all about by like how fees will be paid. Now determination of the fee, chapter 3. Okay, fees को कैसे हम determine करेंगे, how fee will be determined. So let's start with section 10. Is there any doubt from the earlier chapter? Please tell me. Yes, any doubt? Section 4, if you will not pay fee, what will happen? So your document will not be filed, exhibited, कुछ नहीं होगा. Okay, अगर आप गलती से रिसीव कर देते हो डॉक्यूमेंट, तब अगर फी पे नहीं की और डॉक्यूमेंट रिसीव हो गया तो यू विल गेट अ टाइम टू पे फी. ओके, इफ यू आर नॉट पेड, इफ यू आर पेड विद इन दैट टाइम, In that case, it will be paid. It will be deemed that it is paid in the first instance. Multifarious suits, जब एक ही सूट में different reliefs आप claim कर रहे हो, तो अगर वो रिलीफ एक ही कॉज ऑफ एक्शन से है तो आप उसका एग्रीगेट निकाल दो. ओके, अगर वो रिलीफ डिफरेंट कॉज ऑफ एक्शन से है तो उसमें जो हाईएस्ट होगा दैट विल बी अलाउड. अगर वो रिलीफ अल्टरनेटिव मांग रहे हो आप, ओके, इन दैट केस अगेन द हाईएस्ट विल बी मेड. ओके, एंड बट इफ देयर आर वेरियस रिलीफ फ्रॉम वेरियस कॉज ऑफ एक्शन तो उन सबका एग्रीगेट हो जाएगा. Then determination of market value. Okay, so how market value will be determined? So generally it is determined as the value of property on the date of presentation of claim. How? For certain sections, if a rent is settled, then 25% of that rent. If rent is not settled, then जो neighborhood में land होगी उसका 25%. Okay. Then comes set off a counter claim. So उसके लिए भी एक court fee pay की जाएगी. Okay, it is also treated as separate suit and a court fee will be payable. Now, when a document falls under two or more separate descriptions, then the highest fee will be paid. Okay, but when there is one special description, one general description, then special will prevail and fee will be according to the special, even if it is lower. So this is chapter 2 all about. Moving on to chapter 3, determination of fee. Okay, how fee will be determined. So it says statement of particulars of subject matter of suits and plaintiff's evaluation thereof. In every suit in which the fee payable under this act on the plaintiff depends on the market value of the subject matter of suit. अगर कोई भी एक सूट है, ओके, जिसकी फीस जो है वो सब्जेक्ट मैटर की मार्केट वैल्यू के अकॉर्डिंग डिटरमाइन की जाएगी. The fees of that suit depends on the market value of that subject matter. In that case, the plaintiff shall file with the plaintiff a statement in the prescribed form of particular of subject matter of such suit and its valuation, unless such particulars and valuation are already contained in the plaintiff. So what they are saying is when the fees of that suit is decided according to the market value of property. In that case, जब plaintiff अपनी plaint file कर रहा है, तो how he calculated the market value of that property, that document should also be attached. Okay, वो document भी उस plaint के साथ attach होना चाहिए unless you have already written all those things in your plaint. If you have already mentioned all those things in your plaint, then it's fine. But if you are not, then you just need to attach the document in the along with the plaint. Now, decision as to proper fee. In every suit instituted in any court, the court shall, before ordering the plaint to be registered, decide on the material and allegations contained in the plaint and on material contained in the statement, if any, the proper fee payable, the decision being, however, subject to review, further review and correction in the manner specified. So, whenever a plaint is filed in the court, okay, every suit when a suit is instituted, when a plaint is filed, जैसे आप plaint file करोगे तो suit institute हो जाएगा. So when a suit is instituted in court, before before registering the plaint को register करने से पहले, see, just underline this, before ordering the registration of plaint, okay, the court will decide the subject matter and the value of suit. Okay, court decide करेगा, court देखेगा उन documents को which you have attached. Okay, see, if any filed under section 10. Section 10 में जो भी आप documents along with plaint file कर रहे हो, court will read those documents. Okay, after reading the documents, court will see whether the fee is same or not. Okay, whether the fee written here is correct or not. Okay, and then pass the order whether it should be registered or not. Now, suppose court has passed the order not to register it because fee is not appropriate. That order is subject to review, okay, and correction. उस order को review भी किया जा सकता है if you will make an application and it can be corrected also. So this is as decision as to proper fee. Now, any defendant may plead that subject matter has not been properly valued. Now, this is not only the court's duty to check that, but also defendant can plead. Defendant भी इसको plead कर सकता है कि subject matter properly valued नहीं है या जो fee pay की है वो sufficient नहीं है. Then all question arising on such plea shall be heard and decided before the hearing of the suit. ये जो सारे questions है, any question with regard to this, suit fee or subject matter of the suit or valuation of the suit shall be decided before starting the hearing. Hearing से पहले ये initial चीजें हैं. कुछ चीजें initial होती है. सबसे पहले court is having jurisdiction or not. Second, is it within the limitation or not? Third, fee is paid or not. So all these are primary questions that court needs to determine before starting the hearing. So if even defendant is pleading to that, then court will decide on that before starting the hearing. Then if court decides that subject matter of suit has not been properly valued or fees is not sufficient, the court shall fix a date on which the plaint shall be amended in accordance with the court decision and the deficient fee shall be paid. So अगर कोर्ट को लगता है कि ठीक है सब्जेक्ट मैटर प्रॉपर्ली वैल्यूड नहीं है, प्रॉपर्टी सही से वैल्यूड नहीं की गई है, जो फीस की गई है वो सफिशिएंट नहीं है, court will give them a time. Okay, court will allow them a time on which they will appear and either they will amend the plaint or they will pay the deficit fee. जितनी फी बाकी है they will pay it. ना ही फी पे की जा रही है, ना ही plaint amend की जा रही है. In that case what will happen? The plaint shall be rejected. Okay, just underline this. The plaint shall be rejected, and the court shall pass such order as it deems just regarding the cost of suit. और उस पे उल्टा cost impose कर दिया जाएगा by this court. A defendant added after issues have been framed on the merits of claim may in the written statement plead that subject matter of the suit has not been properly valued. Now suppose issues frame हो गए, उसके बाद you are adding a new defendant. He can also raise this plea. Okay, and all question arising on such plea shall be heard and decided before evidence is recorded affecting such defendant. Evidence record करने से पहले you will decide this matter, and then whatever decision come it will follow according to rule 2. Okay, like subsection 2 के according वो फिर से follow किया जाएगा. If courts come to a decision that is this is not properly valued or incorrect fees paid, then they will give a time to amend the thing. अगर उतने में नहीं होता तो plaint shall be rejected. Now this is a very important term, that plaint shall be rejected. Shall be rejected. Shall means it's mandatory. Court has no discretion whether to take it or reject it. It's mandatory for court to reject it. First thing. Second thing, reject होगा. Dismiss नहीं होगा, reject होगा. Okay, return, dismiss ये चीजें नहीं होती. यहाँ पे होता है the word reject. It will be rejected. Okay. Nothing in this subsection shall apply to defendant added as successor or a representative in interest of a defendant who was on record. So suppose there was a person X who filed a suit against Y. Okay, this Y is defendant. Now everything is decided, court fee वगैरह सब कुछ decide हो गई, and Y is dead. Okay, Y died between the suit. Now a successor will proceed here. Y के जो legal heirs वगैरह होंगे वो वहां पे enter हो जाएंगे. So this section is not applicable on his legal heirs. उस पे applicable नहीं है ये. Okay, because it is already decided. So it is not applicable on the legal heirs. But when this Y has already got an opportunity, okay, जब उस Y को already एक opportunity मिल चुकी है कि आप बता दो कुछ issue है तो, okay, अगर Y ने नहीं बताया तो बाद में successors आके नहीं बता सकते. Next, wherever a case comes before a court of appeal, it shall be lawful for such court, either of its own motion or in the application of party, to consider the correctness of any order passed by lower court with regard to fee. Okay, and to determine that. So, जब भी matter appellate court के सामने आता है, तो either party can also make an application or the appellate court itself can decide on the matter whether the court fees is correct or not. Okay, now see, this is another thing which is very important, the explanation, which says a case shall be deemed to be come before a court of appeal, even if the appeal relates only to a part of the subject matter. आपने अपील पूरे सब्जेक्ट मैटर को ना करके एक पार्ट के लिए ही की है, फिर भी माना जाएगा कि द कोर्ट इज having right to decide on the fees thing. If the court of appeal decides that the fee paid in the lower court is not sufficient, if appellate court thinks that the fee is not sufficient, then court shall require party to pay deficit fee within a particular time. Court कहेगा particular time में आके fees pay कर दो. अगर पार्टी उस टाइम में आकर fees pay नहीं करती, okay, and the default is in respect of a relief which has been dismissed by the lower court. Okay, वो जो default है जिस पे fees is deficit, if it is with regard to a relief which is dismissed by the lower court, and which the appellant seeks in appeal, the appeal shall be dismissed. Appeal dismiss हो जाएगी. Okay, but अगर वो जो deficit fee है वो ऐसे decision पे है जो lower court ने decree कर दिया, like a decision which is favored by lower court, which is passed by lower court. In that case, the deficit fee shall be recoverable as if it is an arrear of land revenue. तो वो जो deficit fee है वो ऐसे recover की जाएगी like an arrear of land revenue. Now, how arrear of land revenue is recovered? That is in CPC by attachment, by all these things. सेल अटैचमेंट वगैरह से अरियर ऑफ लैंड रेवेन्यू रिकवर करते हैं, तो वैसे ही उसको रिकवर किया जाएगा. सो इट्स वेरी सिंपल. व्हेन द कोर्ट फी इज विथ रिगार्ड टू अपील विच इज अपील आपने जो की है वो इस डिसीजन से की है जो लोअर कोर्ट ने डिसमिस कर दिया है, और आप कोर्ट फीस नहीं पे कर रहे हो तो आपकी अपील भी डिसमिस हो जाएगी. बट अगर अपील एक ऐसे डिसीजन पे है जो लोअर कोर्ट ने आपके फेवर में किया था, एक्स, सपोज देयर इज टू पार्टी एक्स एंड वाई. ओके, देयर आर टू पार्टीज एक्स एंड वाई. कोर्ट डिक्रीड इन फेवर ऑफ एक्स. Now Y went to court, है ना, Y कोर्ट के सामने जाता है and filed an appeal against this order X. Now, appellate court decided that this was not correctly valued by the lower court. Appellate court will ask him कि भाई फीस पे करो. अगर ये नहीं करता है तो इसको ऐसे रिकवर किया जाएगा जैसे कि लैंड रेवेन्यू का अरियर रिकवर करते हैं. ओके, सिंपल. Now, if the fee paid in the lower court is in excess, अगर आपने lower court में excess fee pay कर दी है, then court shall direct to refund it. Okay, court will बोलेगा कि भाई refund कर दो. Simple. All question as to value for the purpose of determining the jurisdiction of court arising on written statement shall be heard and decided before the hearing of the suit. So whatever question arise with regard to jurisdiction of court, that shall be heard before the hearing of suit. Simple. Subsection 5 is not important. Okay, it's simple कि जो भी jurisdiction को लेके question आते हैं वो आप hearing को start होने से पहले ही decide कर दो. I've told you ना, all these things are preliminary things which have to be decided in the first instance, like whether court is having jurisdiction or not, whether this particular suit is within limitation or not, whether the period is correct or not. So all these things should be decided at the first instance. तो वो court decide कर लेगा accordingly. Then explanation not important, you can just cut it out. Okay, explanation को काट दो, it is not important. Additional fee on issues framed. Okay, now whenever an issue is framed, if there is additional fee, in that case how things will work. So it says when a party becomes liable to pay additional fee by reason of an issue framed in the suit, the provision of the last foregoing section shall apply to the determination of levy of such additional fee to the modification that were party liable to pay. Okay, so it's simple कि suppose court ने एक issue additionally frame कर दिया. Okay, जो आपने demand नहीं किया था ऐसा कुछ court ने issue frame कर दिया. Okay, now for that issue you have to pay additional fee. Okay, suppose you have claim for 2 reliefs, court ने आपको एक और extra issue frame कर दिया. And for the third issue also you have to pay a court fee. For every issue you have to pay court fee. So when an additional issue is framed, you have to pay court fee for that. If you are not paying for that, then what will happen? Then again, the same procedures will be followed. Court will give you a time, okay, to pay the fee within such period. अगर आप तब भी नहीं करते हो, तो court will strike off the issue. Okay, just underline this word. The court shall strike off the issue. What does that mean? Strike off the issue. Strike off means उसको issue को हटा दिया जाएगा. That issue will be removed. Okay, that your issue will not be decided. So if you are not paying court fee on any additional issue, this issue will be struck off after giving you a sufficient time to pay the fee. Then comes section 13, relinquishment of portion of claim. So suppose plaintiff is relinquishing a portion कि भाई मुझे इस claim को नहीं चाहिए, उस case में क्या होगा? So a plaintiff who has called upon to pay additional fee may relinquish a part of his claim and apply to have the plaint amended so that the fee would be adequate for the claim made in the plaintiff as amendment. तो सिंपल कि अगर कोर्ट को कहता है कि भाई हमने एडिशनल चीजें फाइल की है, इश्यूज फ्रेम किए, आप उसके लिए आगे कोर्ट फी पे करो. प्लेंटिफ के पास ऑप्शन है, वो कह देगा भाई मुझे एडिशनल इश्यूज आपसे डिसाइड नहीं करवाने, आप उसको हटा दो. ओके, यू कैन जस्ट रिमूव द एडिशनल इश्यूज, यू कैन अमेंड द थिंग एंड आप ओरिजिनल इश्यूज मतलब उसको टोटल वैल्यू आप प्लेंट को अमेंड करके आपने जितनी ओरिजिनली फी पे की थी वहां तक ला सकते हो. ओके, जो एडिक्वेट फी आपने पे की थी ओरिजिनली, आप उसको अमेंड करके उस लेवल तक ला सकते हो. ओके, एंड देन कोर्ट विल अलाउ यू टू डू दैट. But it shall be done at the prior stage only, not at on any later stage. Okay, it should not be done at the later stages. It should be done at prior stages before the things are decided. Next, fee payable on written statement. So what will be the fee that will be payable on written statement? So where there is a fee payable under this act on a written statement, the provision of section 11 shall apply to the determination and levy of the fees. So same procedures ऊपर वाले apply हो जाएंगे. Okay, fee. What is the procedure of 11? That this one. That he will be called to pay within a particular time. अगर वो नहीं आता तो उसका dismiss कर दिया जाएगा. So same thing will be there. Then fee payable on appeals, same thing. अपील में भी अगर कोई fee है तो वो सारे provisions ऊपर वाले ही applicable होंगे. But there is one thing different. Okay, what is that? See, even if appeal from the judgment of single judge of High Court of Rajasthan under any law for the time being, उसके लिए भी same rules applicable होंगे. Okay, so this is single judge of Rajasthan के against भी appeal हो रही है in High Court only. See what happened, no? Generally when a decision is passed by single judge of High Court, appeal उसी court में double bench के सामने होती है. Okay, larger bench के सामने होती है. So that appeal will also be subject to these rules. ये आप ध्यान रखना. Okay, it's not that कि appeal सिर्फ High Court से Supreme Court में होगी तभी ये rules applicable नहीं हो. नहीं. Even if a single judge is passing a decision and उसी High Court के सामने larger bench को appeal हो रही है, उस पे भी court fee applicable होंगी, यही सारे provisions applicable होंगे. Fee payable on petitions application, same rules will be applicable. So this is also similar. Okay. Now court fee examiners, who will examine the court fee. Okay. So the High Court may depute officers to be designated as court fee examiners. High Court will do that. High Court will appoint officers who will be court fee examiners. Now, what they will do is to inspect the records of subordinate court with a view to examine the correctness of representation made to an order passed by courts. So वो officers determine करेंगे कि जो भी fees high court ने like lower courts ने accept की है was that correct or not. If any order is passed by them, was that correct or not? Okay. And also with like related to valuation of property, that have they sufficiently valued the property or not. Now, if what they will do, they will submit the report. Okay, after deciding all these things, they will submit the report. So, in that report submitted by such court fee, if any question is raised, okay, then to any suit, appeal, or other proceeding pending in a court shall be heard and decided by such court. Okay, what is that such court? Such court कौन सा है? कौन decide करेगा? What is that such court here? Is that high court or the same court? Yes. Anyone, please write down in the chat box what does the word such court means here. So it will be the appellate court. Okay, the appellate court, that means the high court. Just be court के सामने वो high court के सामने वो अपनी report submit करेंगे. Okay, then high court will decide the things on that. Okay, it will be heard and decided by the high courts, and also it can be reviewed and reheard by the court. Okay, so it shall be lawful for the court to rehear on any earlier decision given by the court on the same question. तो अगर इस question पे on this question, if any decision is given by the high court can review the same decision. Okay, so this is court fee examiner, section 17 आप याद रखना, under which section court fee examiner is appointed, deputed. Section 17 is the answer. Then comes section 18, inquiry and commission. Now, for the purpose of determining the subject matter of suit or other proceeding, whether it is properly valued or not, court एक inquiry भी बिठा सकता है. Court may hold such inquiry as it consider proper. Okay, that plaintiff ने जो value दी है property की, क्या वो proper है या नहीं, उसके लिए court एक inquiry बिठा सकता है. For that inquiry, court can issue commissions. Okay, to proper person who will go there, inspect the property, and then make the report. Okay, so that is what inquiry is. Now, notice to the state government. When any inquiry will be made, in any inquiry relating to court fee on a plain written statement, memorandum, and all these documents, in so far valuation affects the fee payable, the court may, if it's considered just or necessary, give notice to the state government. And where such notice is given, the state government shall be deemed to be a party to the suit. See, basically it simply says that जब भी ऐसी कुछ inquiry हुई है, okay, कि whether the particular property is correctly valued or not, तो वो उसकी जो valuation का notice है वो state government को भी दिया जा सकता है. Court can give notice to state government also. Okay, in that case, state government उस suit की party हो जाएगा. State government will appear before the court and answer to the question whether it is properly valued or not. That's it. Okay, this is notice to state government. That in case of inquiry for the valuation, the notice can be sent to state government, then state government will become the party. Okay, and then other proceeding will be according to the decision of the court. This is chapter 3. Okay, so chapter 3, let's do a quick revision. It simply says certain things. Yeah. So how fees will be determined? So सबसे पहले statement of particular subject matter of suits and valuation will be done as per the market value of the suit. Then decision as to proper fee. Proper fee है या नहीं ये कौन decide करेगा? So before registering the particular plaint, court have to decide this thing. When court thinks that fee is not properly made, what court will do? Court will give a time to amend the plaint or pay the fee. If the party is not either amending the plaint or not paying the fee, the plaint shall be dismissed. Sorry, plaint shall be rejected. Okay, but that order is subject to review. उसको review भी किया जा सकता है. Then the next thing, that is section 12, additional fee on issuance of additional fee on issues framed. So if any issues is already framed, fees are already paid and court is adding additional issues. Okay, तो उस पे जो fees होगी, additional issues पर जो fee होगी, ओके वो कोर्ट पार्टी को बुलाएगा कि आप एडिशनल फी पे करो. अगर पार्टी नहीं करती तो कोर्ट स्ट्राइक ऑफ कर देगा इश्यूज को. देन रेलिंक्विशमेंट ऑफ पोर्शन ऑफ क्लेम. पार्टी हैव अ राइट कि वो अपने पोर्शन ऑफ क्लेम को रेलिंक्विश कर दे और ओरिजिनल फीस तक उसको ले आए प्लेंट को. रिटन स्टेटमेंट में भी आपको फीस पे करनी होगी, अपील्स में भी करनी होगी, पिटिशंस के लिए भी करनी होगी. देन अ कोर्ट फी एग्जामिनर विल बी देयर हु कैन जस्ट लुक इनटू द ऑल द थिंग्स दैट जो भी ऑर्डर्स कोर्ट ने पास किए, वैल्यूएशन कोर्ट ने की, वो करेक्ट है या नहीं, एंड दैट एग्जामिनर विल बी अपॉइंटेड बाय हाई कोर्ट. ओके, देन वॉट एवर क्वेश्चंस द एग्जामिनर फील्स फिट ही विल सबमिट टू हाई कोर्ट. अपनी रिपोर्ट सबमिट करेगा, हाई कोर्ट विल डिसाइड ऑन दैट, एंड वॉट एवर ऑर्डर इज पास बाय कोर्ट that is subject to review. 18 talks about inquiry and commission. For the purpose of deciding subject matter valuation, कोर्ट एक कमीशन भी भेज सकता है किसी को, लोकल इंक्वायरी भी करवा सकता है. Okay, and also can send a notice to state government who will then be the party of the suit and will accordingly. So yeah, this 18 is not that important. Sorry, 19 important नहीं है. आप इसको simple याद रखो, state government को notice जा सकता है. Okay, and इसमें सिर्फ इतना ध्यान रखना कि when a notice is sent to state government, the state government can become the party. Okay, state government will become the party. That thing is important. Then chapter 4, computation of fee. Okay, so how reckon? Fee कैसे reckon होगी? So the fee payable under this act shall be determined or computed in accordance with the provision of this chapter, chapter 6, chapter 8, chapter schedule 1 and schedule 2. Fees कैसे count करोगे? आप fees किस दिन से कैसे count करोगे? So that's decided in all these chapters. This chapter, computation of fee, chapter 6, chapter 7, chapter 8, then 1 and 2. है ना, schedule 1 and 2 हमने already देखे हैं. 1 है कि when there is valuation तो हम क्या fee रखेंगे. Then there is fixed relief, उनके लिए क्या fee होगी. तो according to all these chapters and schedules, we will decide the court fee. Then suits for money. In a suit for money, when it's a money suit, okay, which includes damages, compensation, maintenance, annuities, ये सारे जो suits है, fee shall be computed on the amount claim. जितना आप amount claim कर रहे हो, उसके according fees आपकी payable होगी. Okay, provided that in an action or suit damage under Fatal Accident Act, a fixed fee of ₹10 shall be payable on the plaint or memorandum of appeal. इसको ध्यान रखना, ये बहुत इंपॉर्टेंट है. फेटल एक्सीडेंट एक्ट के अंदर अगर आप कोई भी डैमेजेस के लिए सूट फाइल कर रहे हो तो उसकी जो फी है दैट इज फिक्स, दैट इज ₹10. मेंटेनेंस एन्युइटीज के लिए जो सूट्स है उनकी फीस क्या होगी? सो इन अ सूट ऑफ मेंटेनेंस in the suits herein before, the fee shall be computed as follows. So अगर मेंटेनेंस का सूट है तो the amount claim to be payable for 1 year, accordingly the fees will be calculated. आप एक ईयर के लिए कितना अमाउंट क्लेम कर रहे हो, ओके, उतनी फीस आपकी कैलकुलेट की जाएगी. इन अ सूट फॉर एनहांसमेंट और रिडक्शन ऑफ मेंटेनेंस, अगर आप मेंटेनेंस को एनहांस या रिड्यूस करवा रहे हो तो ऑन द अमाउंट विच एनुअल मेंटेनेंस इज सॉट टू बी एनहांस्ड और रिड्यूस, जितना आप एनुअल मेंटेनेंस सॉट और रिड्यूस कर रहे हो, ओके, लाइक एनहांस और रिड्यूस करवा रहे हो, उस पे आपके फी पेबल होगी. इन अ सूट फॉर एन्युइटीज ऑन 5 times द अमाउंट क्लेम टू बी पेबल फॉर 1 year. अगर आप एन्युइटीज के लिए या अदर सम्स के लिए पीरियोडिकली जो पेबल होते हैं, एन्युइटीज मीन्स जो एनुअली कुछ फी आपको पेबल होती है, कुछ इनकम आपकी एनुअली हो रही है, दैट इज एन्युइटीज. या फिर कुछ पीरियोडिकली हो रही है, लाइक 1 month 2 month, एवरी मंथ यू आर गेटिंग अ पर्टिकुलर अमाउंट ऑन दैट thing, okay, how you will pay the fee. So it will be payable on 5 times the amount claimed to be payable for 1 year. So if suppose 1 year के लिए आप amount pay कर रहे हो 5,000 rupees, so they will calculate your fee on 5,000 5 times of 5,000. They will calculate, that means 25,000 पे आपकी fees calculable होगी. Provided that where annuity is payable for less than 5 years, अगर annuity 5 years से कम है, the fee shall be computed on the aggregate of sum payable. Okay, see annuities generally ईयर टू ईयर होती है, बट अगर वो ईयर टू ईयर आपका 5 ईयर से कम है, इट्स ओनली फॉर 3 ईयर और 4 ईयर, तो उन 3 ईयर और 4 ईयर का जो एग्रीगेट होगा उस पर आपका फीस पेबल होगा. ओके, सो वील डू अ क्विक रिविजन. मेंटेनेंस का सूट है, एक साल में आप जितना मेंटेनेंस क्लेम करते हो उस अमाउंट पे आपकी फीस डिसाइड होगी. एनहांसमेंट और रिडक्शन है मेंटेनेंस का, एनहांस और रिड्यूस करने के बाद एक साल में जो आपका एनुअल मेंटेनेंस होगा उस पर आपकी फीस पेबल होगी. अगर वो एन्युइटीज पे है तो वॉट एवर एन्युइटीज इज देयर एनुअली 1 ईयर की, उसका 5 times आपका हो जाएगा. बट अगर वो 5 ईयर से कम है तो उस केस में उन सबका एग्रीगेट, ओके, देयर विल बी एग्रीगेट. नाउ दिस इज नॉट इम्पॉर्टेंट, प्रोवाइडेड वाला इसको छोड़ दो. 23 is again very important, suits for movable property. Okay, so when there is a movable property, how fees will be calculated. So it says in a suit for movable property, other than documents of title, fee shall be computed. If you are filing a suit for movable property, other than document of title को छोड़ के अगर आप किसी movable property के लिए suit file कर रहे हो, okay, what will be the fee for that? So fee shall be computed where the subject matter has a market value, then on such value. अगर subject matter की कोई market value ही नहीं है, okay, suppose I am calculating a fee for a pen or a handbag, let's say a handbag, okay, and whatever the market value of handbag is, 3,000, 4,000, the fee will be payable on that. Okay, it will be on such market value. But suppose the subject matter is having no market value, उसकी कोई market value नहीं है. Okay, it's simply like I have grown a new type of grains, मैंने एक नया grain बनाया है, उसकी अभी तक कोई market value decide नहीं हुई है. In that case, how will the subject matter, how will the market value be decided, how will the fees be decided for that. तो अगर उस नए ग्रेन का कोई मार्केट वैल्यू ही नहीं है, तो ऑन द अमाउंट एट विच द रिलीफ सॉट इज वैल्यूड इन द प्लेट, तो जो मैं रिलीफ मांग रही हूँ उस रिलीफ का क्या अमाउंट है, व्हाट अमाउंट ऑफ रिलीफ आई एम क्लेमिंग, आई वांट 5,000, 10,000, 20,000, हाउ मच रिलीफ आई एम क्लेमिंग, okay, on that amount the court fee will be computed. I hope this is clear. Okay, when it's a movable property other than document of title, in that case, if the market value is decided, then according to market value, your fee will be decided. When there is no market value to the subject, then the amount of relief which I'm claiming, according to that, my fee will be decided. नेक्स्ट, इफ इट्स अ सूट फॉर पोजेशन ऑफ डॉक्यूमेंट ऑफ टाइटल, अगर हमने ऊपर देखा था डॉक्यूमेंट को टाइटल के छोड़ के कुछ है तो क्या होगा, अगर वो डॉक्यूमेंट ऑफ टाइटल का है तो क्या होगा, देन फी शैल बी कंप्यूटेड ऑन 1/4 ऑफ द अमाउंट और ऑफ मार्केट वैल्यू ऑफ द प्रॉपर्टी सिक्योर्ड बाय द डॉक्यूमेंट्स. सो उन डॉक्यूमेंट्स, वो डॉक्यूमेंट्स जिस प्रॉपर्टी को सिक्योर कर रहे हैं, सपोज द डॉक्यूमेंट ऑफ टाइटल इज फॉर दिस पेन, ओके, दिस इज डॉक्यूमेंट ऑफ टाइटल ऑफ दिस पेन, देन व्हाट इज द मार्केट वैल्यू ऑफ दिस पेन, ओके, इस पेन की मार्केट वैल्यू क्या है, उसका 1/4 होगा उस डॉक्यूमेंट ऑफ टाइटल की फीस. सी, इन अ सूट फॉर पोजेशन ऑफ डॉक्यूमेंट ऑफ टाइटल, फी शैल बी कंप्यूटेड ऑन 1/4 ऑफ द अमाउंट ऑफ द मार्केट वैल्यू ऑफ द प्रॉपर्टी सिक्योर्ड बाय द प्लेट. ओके, सो या तो वो 1/4 अमाउंट हो जाएगा उसका, ओके, or the market value of property secured by the document. Suppose this document is securing this pen, then इस पेन की जो मार्केट वैल्यू होगी that will be the fee. So आपको ध्यान रखना है डॉक्यूमेंट ऑफ टाइटल के केस में either 1/4 of the amount, okay, whatever amount you are claiming उसका 1/4, या फिर market value of property secured by the document. Where the plaintiff alleges denial of the plaintiff's title to the money or the property secured by the document, where an issue is framed regarding the plaintiff's title, this is not important. Not important. You can just skip this one. Okay, important नहीं है. In a suit for possession of documents of title where the plaintiff's money, okay, this is also not important. इसमें सिर्फ इतना ध्यान रखना है आपको डॉक्यूमेंट ऑफ टाइटल में कि क्या वैल्यू होगी, ओके, तो इफ बस ये दो चीजें आपको ध्यान रखनी है फॉर यहाँ तक, ओके, फ्रॉम हियर टू हियर, subsection 1 and subsection 2 first clause, okay, that is only important from your prelims perspective. Okay, so if it's a document of title, then either 1/4 of the amount that you're claiming or the market value of the property which is secured by the document. If it is not document of title, then market value of property. If that property is having no market value, then the relief you are claiming. Okay, जितना relief आप मांग रहे हो उसका amount. Next. Now 24, suits for declaration. Okay. So it says, what is declaration? First and foremost, what is declaration? What do you mean by declaration? Then we will discuss suits for declaration. So declaration means that suppose I'm having a right in my favor. Okay, this is a property X which belongs to me. And there is a person Y who is saying that you are not the owner of this property. Okay, तुम इस property के owner नहीं हो. I'm going to file a suit against you and will, remove you from the possession of the property. So now I will go to court and ask for a relief that give me a declaratory decree. Okay, give me a declaratory decree, give a declaration to the person. You pass a decree against the person that this property belongs to me and now he will not, deny to my rights over the property. So वो उसको declaratory decree कहते हैं. कोर्ट एक declaration करवाता है कि ठीक है ये property इस person को belong करती है. So it says, in a suit for declaratory decree or order, whether with or without consequential relief not falling under section 25. So if it's a declaratory decree का suit which is not falling under section 25, 25 is adoption suits. ये declaration जो है आप adoption के लिए नहीं करवा रहे हो, that this person is my son, okay, this person is my daughter. अगर आप इसका declaration नहीं करवा रहे हो, adoption का declaration नहीं है, okay, it's a declaration with regard to any other thing. In that case, where the prayer is for declaration for possession of property, okay, the fee shall be computed on the market value of property subject to a minimum fee of 20 rupees. तो अगर आप किसी possession of property के लिए declaration करवाना चाहते हो तो that fee will be the market value of property. Okay, जो fee होगी वो property की. See, when we say no, fee shall be computed on the market value of property, it does not mean that suppose market value of property is 30 rupees, तो आपकी fees भी 30 होगी. No. Shall be computed means if 30 rupees is market value of property, then this will be the fee. Okay, what will be the fee? That is given in like schedule 1. Okay, so अगर 30 rupees आपकी market value है property की तो fee जो है वो schedule 1 में दे रखी है. ऐसा नहीं है कि market value 30 है तो fees भी 30 है. No, It will be computed on the market value. Okay, but minimum 20 rupees तो होना ही चाहिए. Now, if the declaration is for consequential injunction, आप injunction का declaration करवाना चाह रहे हो, okay, then fee shall be computed on 1/2 of the market value of property. अगर injunction का declaration करवाना चाहते हो तो fee will be 1/2 of the market value of property. Where the prayer relates to the plaintiff's exclusive right to use, sell, print, or exhibit any mark, name, book, picture, design, or other thing. Suppose plaintiff is having exclusive right over a particular thing. Okay, that this pen belongs to me. Only I can sell the pen. I am having trademark, copyright. अगर ऐसा कुछ सूट है, तो उसमें क्या फीस रहेगी? तो fee shall be computed on the amount at which the relief sought is valued. तो मैं जितना रिलीफ मांग रही हूँ उस पे मेरा फी डिसाइड होगा. Where the prayer is for declaration with reference to any property and no consequential relief is paid. Okay, prayer जो है वो किसी property के लिए और कोई consequential relief नहीं है. Then fee shall be computed on the market value of property, but minimum 20 rupees. In other cases where the subject matter of the suit is capable of valuation or not, अगर subject matter valuation के लिए है या नहीं, दूसरे कोई भी matters में, even if it is valuable or not, okay, fee shall be computed on the relief sought, but minimum again 25 rupees. Okay, so yeah, and in this one, when it is for picture design and all, minimum 40 rupees fees honi chahiye. So all these are minimum fee. But apart from that, this is how we will decide the fee. So how for अगर possession के लिए है तो market value of property. अगर injunction के लिए है तो 1/2 of the market value. अगर rights to use, sell, print उसके ऊपर है तो again whatever relief you are sorting. See, इसको ऐसे याद रखो. Possession, injunction, trademark and patent are all. Okay, possession, injunction, trademark, patent, then consequential relief and other. Okay, so for patent, trademark, it is 1/4 of the market value. Sorry, for patent, trademark, it is the relief that you sought. For injunction, 1/4 of the market value. For possession, market value of subject matter. Then for consequential relief, again market value. Okay, and other cases, again the relief. Okay, so for trademark and other cases, it is the relief that you sought. For injunction, it is value of the property. Okay, 1/4 of the value of property. And for possession and consequential relief, it is market value. तो आपको simply ये ध्यान रखना है. Okay, now generally it is 20 rupees. सिर्फ ट्रेडमार्क पेटेंट का 40 rupees है and other cases में it's 25 rupees. Otherwise, it's minimum of 20 rupees. Then adoption suits. Section 25. In a suit for declaration in regard to the validity or invalidity of an adoption or factum of adoption. Okay, अगर वो adoption का suit है, तो अगर आप adoption के लिए declaration लेने जा रहे हो, okay, that this person belongs to me, I have adopted my son, I have adopted my daughter, and I want the person to not to deny to his rights. In that case, what will be the fee? Okay, so where the market value of property involved and affected by the relief is rupees 5,000 or less than 25 rupees 50. अगर 5,000 से कम है तो 50, अगर 5,000 से ज्यादा है बट 10,000 तक है तो 100, 10,000 से ज्यादा है तो 500. Okay, that will be for adoption, like declaration for adoption. Next is suit for injunction. So in a suit for injunction where the relief sought is with reference to any immovable property, अगर आप immovable property के लिए कुछ injunction लेने जा रहे हो, okay, और where the plaintiff alleges that his title to property is denied, या फिर plaintiff कह रहा है कि मेरा title ही deny कर रहा है, then fee shall be computed on 1/2 of the market value of the property or on rupees 300, whichever is higher. See, all these things are, like very simple things. There is no need to explain anything. They are very simple and sorted things. It's just that you have to make a table, okay, that in this case, what will be the fee? In this case, what will be the fee? And you have to remember the things. That's it. Okay. So, like, इसमें ऐसा कुछ नहीं है कि exceptional है. What does it mean? क्या मतलब हो गया इसका? ऐसा कुछ भी नहीं है. Everything is very simple. When you will read it for once, you will get it. You will get everything. Okay. It's just that you have to make a table and remember all the things. Okay. Because you cannot imagine कहाँ से क्या question आ जाए. We can never imagine. Okay. So आपको table बनानी ही पड़ेगी. हर चीज याद करनी ही पड़ेगी. There is no other option that you have. Next, where the prayer relates to the plaintiff's exclusive right to use, sell property, all these infringement and thing, then the fee shall be computed. See, this one is for injunction. Okay, वो अर्लियर वाला डिक्लेरेशन के लिए था. आप अभी सोच रहे होंगे कि मैम पहले भी तुमने ट्रेडमार्क का पढ़ा है. ओके, बट जब हमने पहले ट्रेडमार्क का पढ़ा वो डिक्लेरेशन का था. ये जो ट्रेडमार्क कॉपीराइट है ये इंजंक्शन के लिए, तो अगर आप इन पे इंजंक्शन चाह रहे हैं, ओके, इन दैट केस फी शैल बी कंप्यूटेड ईदर ऑन द रिलीफ सॉट और ऑन ₹500 विच एवर इज हायर। अगर ₹500 से ज्यादा की आप रिलीफ मांग रहे हो तो आपने जो रिलीफ मांगी है उस पर वैल्यू होगी, बट अगर रिलीफ मांगी है वो लेसर है तो ₹500 पे फीस आपकी पेबल होगी। In any other case where the subject matter of the suit has a market value or not, the fee shall be computed as according to the relief which is sought, or ₹400, whichever is higher. So again, the same thing, you have to learn all these things by making a table. Suit relating to trust property. So in a suit for possession of joint possession of trust property or for declaratory, whether with or without consequential relief in respect of it between trustees, rival claimants to the office of trustee, or between a trustee or a person who has ceased to be trustee. So it's basically all the persons who are trustee. Okay. So उसके अगर ट्रस्ट के अगेंस्ट कोई भी सूट फाइल कर रहे हो, ओके, इट्स सिंपल, इन टोटल आप इतना समझो कि ट्रस्ट के अगेंस्ट कोई सूट फाइल कर रहे हो, दे आर जस्ट डिफाइंड डिफरेंट डिफरेंट टाइप्स ऑफ ट्रस्ट, ओके। सो इवन इफ इट्स वन ट्रस्ट, ओके, और टू ट्रस्टीज, वन ट्रस्ट एंड टू ट्रस्टीज, ओके, और टू राइवल ट्रस्टीज, कोई भी लाइक ए एंड बी, दो अलग अलग ट्रस्ट है और उनके जो ट्रस्टीज है, ओके, और द पर्सन हु इवन सीज टू बी ट्रस्टी, पहले ट्रस्टी था बट अभी नहीं है, लेकिन आप उस कैपेसिटी में उस पर सूट फाइल कर रहे हो, देन इट विल बी 1/5 ऑफ द मार्केट वैल्यू ऑफ प्रॉपर्टी सब्जेक्ट टू द मैक्सिमम फी ऑफ ₹200। सो 1/5 ऑफ द मार्केट वैल्यू ऑफ प्रॉपर्टी, लेकिन मैक्सिमम 200 होना चाहिए, ओके, उससे ज्यादा नहीं। एंड वेयर द प्रॉपर्टी हैज नो मार्केट वैल्यू ऑन ₹1000, provided that where property does not have a market value, value of the purpose of determining the jurisdiction shall be such amount as the plaintiff shall state in the plaint. अगर अब प्रॉपर्टी का कोई मार्केट वैल्यू ही नहीं है, ओके, तो अमाउंट ऑफ प्लेंट कैसे होगा? हाउ विल यू डिसाइड द jurisdiction of the court? In that case, whatever relief you are claiming in the plaint, according to that, your jurisdiction will be decided. Then 28, सूट फॉर पोजेशन अंडर एसआरए। एसआरए में आपको पोजेशन के लिए अगर कोई सूट चाहिए अंडर सेक्शन 9, ओके, it's not 9, it's 6. It's 6. Please make it 6. In a suit for possession of immovable property under Section 6 of SRA, fee shall be computed on 1/2 of the market value of the property, or ₹200, whichever is higher. Suit for possession not otherwise provided. Any suit for possession of immovable property for which not otherwise provided, like provided nahi hai kahin pe uski value. In that case, the market value of property minimum ₹20. Suits relating to easement, if there is any suit on easement, in that case, whether by dominant or by servient owner. Now, easement के against आप कोई भी suit हो सकता है. Suit dominant भी कर सकता है और servient owner भी कर सकता है. So, what is dominant and servient owner? I'll just explain you in short. Suppose this is a property, and this is other property. So, let's say this is my second floor. Okay, I'm like getting a right of easement to get air from this property because property A. This is property A, this is property B. Property A is not having second floor. Okay, तो मेरे पास एक राइट है कि मैं यहाँ से एयर ले सकती हूँ और ये राइट मेरे पास 20 years तक है। 20 years तक प्रॉपर्टी ए हैज नॉट कंस्ट्रक्टेड सेकेंड स्टोरी। ओके, नाउ आई हैव गॉट एन ईजमेंट राइट। सो द प्रॉपर्टी हु इज गिविंग दिस ईजमेंट राइट, जो प्रॉपर्टी अपना राइट दे रहा है किसी को, उसे कहा जाता है सर्विएंट ओनर। Okay, the owner of this property will be called as servient owner because this property is serving property B. ये इसको सर्व कर रही है, अपनी तरफ से easement दे रही है, so he is servient owner. And the property B who is getting easement right, okay, he is dominating property. वो property A को dominate कर रही है because for the better use of property B, property A is serving him. So in that case, this property B's owner will be called as dominant owner. So in case of easement, if it's a suit relating to easement, फिर वो चाहे dominant owner करे या servient owner करे, the fee shall be computed on amount at which the relief sought is valued in the plaint. Fees क्या होगी? जो relief मांगी है उस पर decide की जाएगी. But in no case it shall be less than ₹200. In no case it shall be less than ₹200. Where compensation is claimed beside other relief relating to such easement. अगर easement के अलावा आपने compensation भी मांगा है, okay, is in this suit, in this particular suit, apart from easement, if you have claimed compensation also, then fee shall be paid on the amount claimed as compensation in addition to fee payable for such relief. तो easement का जो fee है वो तो लगेगा ही, उसके additional में जो आपने compensation मांगा है उस पे भी आप पे fees impose की जाएगी. Then comes preemption suits. In case of preemption suit, fee shall be computed on the amount of consideration for the sale. आप जितने amount में property sell करना चाहते हो उस पे वो suit की fees will be decided. Okay, which the preemptor seeks to avoid, or on the market value of the property sold, whichever is less. दोनों में से जो less होगी, या तो amount of suit or the market value of property, दोनों में से whichever is lesser, okay, that will be payable. Now, suits relating to mortgages. If it's a suit on mortgages, okay, in a suit to recover the money due on mortgage, fee shall be computed on the amount claim. Mortgage में अगर फीस है तो जितना आप अमाउंट क्लेम कर रहे हो उस पे फीस पेबल होगी. Okay, but it is for money due on mortgage. Suppose A is a person who has given 5,000 to B and for which B has kept a property mortgage. अब अगर A suit file कर रहा है that I want to recover my money, okay, whatever money is due, I want to recover that. That means I want my 5,000. In that case, whatever amount is claimed, okay, he is claiming 5,000. तो जितना वो amount claim कर रहा है उस पे fees will be valued. Where in such a suit the holder of prior mortgage or charge is impleaded and he prays in his written statement that amount due on mortgage or charge be determined and that the decree contain a direction for payment of such amount, fee shall be payable on the written statement computed on the amount claimed. Okay, now see, there is a prior mortgager. Okay, एक prior mortgage था या charge था और वो they want to set off the amount. Okay, they want to set off the amount of prior mortgage. Then fee shall be payable on the written statement computed on the amount claimed. जो रिटन स्टेटमेंट में वो सेट ऑफ के लिए प्रायर मोर्टगेज को लिख रहा है कि देयर वाज आल्सो प्रायर मोर्टगेज व्हिच वाज देयर, तो रिटन स्टेटमेंट में इफ ही इज एडिंग एनी सच मोर्टगेज तो उसमें सेट ऑफ कर दिया जाएगा फीस को एंड देन इट विल बी पेबल. देन थर्ड, वेयर इन सच अ सूट द मोर्टगेज प्रॉपर्टी इज सोल्ड. ओके, सपोज द मोर्टगेज प्रॉपर्टी इज सोल्ड and the holder of a prior or subsequent mortgage or charge applies for payment to him. जो subsequent mortgager है, okay, he applies for payment. Okay, the property is sold, but the subsequent mortgage के लिए जो payment था वो अभी तक नहीं हुआ है. Then out of the sale proceeds of the amount due on his mortgage, such holder of the prior or subsequent mortgage or charge shall pay an application of fee computed on the amount claimed by him. Suppose A gave rupees 5,000 to B, for which B has mortgaged the property. Now what B did, he sold the property. वो property को sell कर देता है. Okay, B sold the property and A is filing a suit to claim this money. In this suit, he is claiming money out of the proceeds of sale. ये property sell करके जो पैसा मिला है आप मुझसे उसमें से मुझे payment कर दो. Okay, तो such holder of prior or subsequent mortgage or charge shall pay on his application a fee computed on the amount claimed by him. Now fee कितना होगा? Fee will be according to the amount that is claimed by the person. Simple. Okay, even if the property is sold on a particular value, but fee just जो amount वो claim कर रहा है उतना ही होगा. Then subsection 4, these provideds are not important from your prelims perspective. You can just skip this thing. Okay. Subsection 4 says in a suit by co-mortgager for the benefit of himself and the other co-mortgagees, fee shall be computed on the amount claim on entire mortgage. अब अगर co-mortgagers है A और B दो mortgagers है, उन्होंने अपनी जो property है वो mortgage करी है B को. Okay, A and B, two co-mortgagers have mortgaged their property to B. In that case, if A and B are claiming any fee, okay, suppose A is claiming any fee, तो ये सिर्फ A के अमाउंट तक का वैल्यू से डिसाइड नहीं होगा. इट विल नॉट बी डिसाइडेड, द फी विल नॉट बी डिसाइडेड ओनली टिल द अमाउंट ऑफ वैल्यू ऑफ A, even though only A is claiming, okay, but still it will be decided in the whole subject matter. पूरे entire mortgage का जो पैसा है उसके according that will be decided. Okay, suppose it was mortgage for 5,000, 2,500 for A, 2,500 for B. So the fee will not be according to 2,500. Even if A is claiming only 2,500, but fee will be decided according to the whole mortgage. Okay, entire amount of mortgage, the fee will be decided. And this subsection 4 is very important. In case of co-mortgager, okay, fee सिर्फ एक mortgage के rate से decide नहीं होगी. It will be decided according to the entire mortgage value. These things you can just skip. Now subsection 5, let's come to this. Subsection 5 says that in a suit by a sub-mortgagee means A has mortgage to B, B has mortgage to C. Okay, then C will be sub-mortgagee. If a suit is filed by sub-mortgagee to recover the amount claimed on the sub-mortgage by sell, fee shall be computed on the amount claimed under sub-mortgage. So fee जो sub-mortgage का amount होगा उसके ऊपर होगी. It's very simple. Six is not important. 7, when the original mortgage was impleted, this is also not important. 7 भी हटा दो. In a suit against a mortgage for redemption of, yeah, this is important. 8 is important. Okay, 8 is important. You can just mark it. This is very important. It says in a suit against a mortgage for redemption of a mortgage. अगर आप redemption का suit file कर रहे हो, if you're filing a suit for redemption, fee shall be computed on the amount due on mortgage as stated in the plaint. Okay, redemption के case में जितना amount due. See what is redemption? Redemption means I want to redeem my property back. I have paid the money. Now I want to take my property back. So in that case जितना amount आपने आगे वाले से लिया था, उस पे आपका fees calculable होगा. Okay. Yeah, now this is important. In a suit by mortgage to foreclose the mortgage. Okay, अगर suit foreclosure का है, उस केस में fee shall be computed on the amount claimed in the plaint by way of principal and interest. तो foreclose के केस में principal plus interest दोनों मिलाकर fee will be calculable. Okay, this is also important. सो इसमें सिर्फ इतना ध्यान रखना, रिडेम्पशन के केस में जो अमाउंट आपने प्लेंट में स्टेट किया था दैट मोर्गेज कितने के लिए ड्यू था, दैट विल बी अकॉर्डिंग टू दैट. ओके, इन केस ऑफ दिस वन, लाइक फोरक्लोजर के केस में प्रिंसिपल प्लस इंटरेस्ट दोनों को मिला के इट विल बी डिसाइडेड. नेक्स्ट इज सूट्स फॉर अकाउंट. ओके, इन केस ऑफ सूट्स फॉर अकाउंट, सॉरी इट गॉट म्यूटेड. ओके, इन केस फॉर सूट फॉर अकाउंट. अब अकाउंट क्या होता है? अकाउंट इज बेसिकली लाइक अकाउंट्स जो होते हैं, लाइक आई हैव पर्टिकुलरली कैटेगराइज्ड अमाउंट ऑफ कोल, लाइक बिजनेस, कि ये मेरे अकाउंट्स है बिजनेस के, ऑल दीज थिंग्स आर द ट्रांजेक्शन, इतना एसेट्स है, इतनी लायबिलिटीज है, दैट इज अकाउंट. ओके, सो इन अ सूट फॉर अकाउंट व्हेन देयर इज एनीथिंग इन अकाउंट, फी शैल बी कंप्यूटेड ऑन द अमाउंट सूट फॉर एज एस्टिमेटेड इन द प्लेंट. तो प्लेंट में जितना आप रिलीफ मांग रहे हो, जो प्लेंट का एस्टिमेटेड अमाउंट है आपकी एसेट्स लायबिलिटीज सब मिला के, अकॉर्डिंगली सूट फॉर अकाउंट की जो फी है दैट विल बी डिटरमाइंड. वेयर द अमाउंट पेबल टू द प्लेंटिफ एज असर्टेन इन द सूट इज एन एक्सेस ऑफ अमाउंट एज एस्टिमेटेड इन द प्लेंट. अब जो अमाउंट पेबल है प्लेंटिफ को, जो सूट में असर्टेन किया गया है, वो प्लेंट के एस्टिमेट से ज्यादा है. ओके, दैट इज मोर देन द अमाउंट दैट इज एस्टिमेटेड इन द प्लेंट. फॉर एग्जाम्पल, इन प्लेंट द अमाउंट एस्टिमेटेड वॉज 5,000. Okay, but see where the amount payable to the plaintiff as ascertained in the suit. Plaint में it's 5,000, but the amount which is payable to him was 10,000. वो ज्यादा हो गया. Okay, plaint में 5,000 था, but जो उसको डिक्री किया वो ज्यादा हो गया. In that case, no decree directing payment as so ascertained shall be passed until the difference between actual fee and the fee would have been payable is set off. तो सपोज ओरिजिनल प्लेंट में 5,000 था, बट जब कॉम्पनसेशन फाइनली डिक्री हुआ तो उसको 10,000 मिल रहा है. तो वो 10,000 उसको तब तक नहीं मिलेगा जब तक वो जो एक्सेस है, 5,000 एक्सेस है, उसका फी पे नहीं करते. ओके, दिस इज इंपॉर्टेंट. सूट्स फॉर अकाउंट. नाउ सेम थिंग, इफ इट इज नॉट पेड विद इन टाइम, देन द डिक्री शेल बी लिमिटेड टू द अमाउंट टू विच द फी इज पेड. अगर एडिशनल उतने टाइम में नहीं करते तो डिक्री सिर्फ उतने तक का आपको पेमेंट मिलेगा जितना आपने पे कर दिया है. ओके, नाउ व्हेन इन एनी सच सूट इट इज फाउंड दैट एनी अमाउंट इज पेबल टू द डिफेंडेंट ऑन द डिक्री shall be passed in his favor until he pays the fee due. अगर डिफेंडेंट को कुछ अमाउंट मिल रहा है डिक्री के अंदर, ओके, इन दैट जनरली प्लेंटिफ फी पे करता है अपना, ओके, अकॉर्डिंग टू वॉट एवर अमाउंट ही हैज क्लेम्ड. डिफेंडेंट फाइल द फी अकॉर्डिंग टू हिज रिटन स्टेटमेंट. ओके, बट इफ in this particular suit any amount is decreed in favor of defendant, आप डिफेंडेंट को कुछ अमाउंट डिक्री कर रहे हो, in that case the defendant also have to pay the fee due on that amount. उस amount में जितना fee लगेगा defendant have to pay that. If defendant is not paying that fee, in that case what will happen? So defendant is not paying, the amount will not be decreed in his favor. Okay, on decree, if a decree is passed in favor, it will not see. A decree shall be passed in his favor until he pays the fee on due amount. Okay, जब तक वो fee नहीं कर देगा decree उसके पास नहीं होगी. Suits for dissolution of partnership. Now, when a partnership is dissolved, okay, a partnership firm is dissolved and you're filing a suit for that, तो उसमें कैसे fees decide होगी? In a dissolution of partnership, fee shall be computed on the value of plaintiff share in the partnership. जो plaintiff का share है उसके ऊपर value decide होगी. अगर plaintiff का share है, okay, if the value in the suit exceeds the value as estimated in the plaintiff, अगर वो estimate से exceed हो जाता है, तो अगेन वही चीज है, फाइनल डिक्री से पहले द पर्सन हैव टू पे दैट. ओके, प्लेंटिफ हैव टू पे द एक्सीड्स अमाउंट, अदरवाइज उसके फेवर में नहीं होगा. नो डिक्री शैल बी पास, नो मनी शैल बी पेड, नो अलॉटमेंट ऑफ प्रॉपर्टी शैल बी मेड इन फेवर ऑफ डिफेंडेंट. अगर डिफेंडेंट को कुछ शेयर मिल रहा है तो अगर वो फी पे नहीं करता तो तब तक उसको भी नहीं मिलेगा. सेम एज द अर्लियर वन. पार्टीशन सूट. In a suit for partition and separate possession in joint family property or property owned jointly or in common, fee shall be on the market value of property. Okay. Next, in a suit for partition and possession of joint family or property owned by plaintiff who is in joint possession of such property, fee shall be paid at the following rates, namely. So rupees 30 if value of plaintiff share is 5,000 or less. Rupees 100 if value is above 5,000 but does not exceed 5,000 to 10,000 के बीच है 100. सी हमने ये सब पहले पढ़ रखा है. ओके 5,000 से कम है तो 30 रुपीज, उससे ज्यादा लेकिन 10 से कम है तो 100 रुपीज, अगर 10,000 से ज्यादा है तो 200 रुपीज. Okay, but see, there's a difference between subsection 1 and subsection 2. What is that difference? Subsection 1 कहता है in a suit for partition and separate possession of a share in joint family property. Okay, by plaintiff who has been excluded from the possession of such property. अगर plaintiff को उससे निकाल दिया है और वो अपना share चाहता है, okay, in that case जो property की market value में plaintiff का share है, that will be according. Subsection 2 कहता है कि अगर it's a partition suit, एक जॉइंट फैमिली प्रॉपर्टी है जिसको पार्टीशन करवाना है तो उस प्रॉपर्टी की वैल्यू के अकॉर्डिंग होगा. ओके, इज दैट क्लियर एवरीवन? आई होप दिस इज क्लियर. इफ प्लेंटिफ वांट्स अ शेयर इन द प्रॉपर्टी हु हैज बीन रिमूव्ड फ्रॉम द प्रॉपर्टी एंड ही वांट्स अ शेयर, इन दैट केस जो प्लेंटिफ के शेयर का मार्केट वैल्यू है उतना आपको वैल्यू फीस डिसाइड हो जाएगी. बट अगर उस पूरी प्रॉपर्टी का पार्टीशन करवाना चाहते हो तो उस प्रॉपर्टी की मार्केट वैल्यू के अकॉर्डिंग डिसाइड होगा. दिस इज बेसिक डिफरेंस बिटवीन सबसेक्शन 1 and 2. ओके, सो don't get confused in the terms कि one में भी partition, separate possession, owned, ये सब है, 2 में भी यही है, तो क्या difference है? There is a word plaintiff's share. Okay, this is the basic difference. अगर plaintiff सिर्फ अपने share के लिए ये सब करवा रहा है, okay, in that case market value of his share. But if it is the partition for entire property, then the value of property. Third, where in a suit falling under subsection 1 or 2, a defendant claims partition and separate possession of his property. अगर 1 और 2 में डिफेंडेंट क्लेम कर रहा है तो फी रिटन स्टेटमेंट में तब तक डिफेंडेंट के फेवर में पास नहीं होगा जब तक वो पे नहीं कर दे. ओके, बट सी फी शैल बी पेबल ऑन हिज रिटन स्टेटमेंट कंप्यूटेड ऑन द हाफ ऑफ द मार्केट वैल्यू एंड हाफ रेट स्पेसिफाइड इन सबसेक्शन 2. सो अगर डिफेंडेंट इज क्लेमिंग दीज थिंग्स देन half of whatever is in subsection 1 and 2 he have to pay that. Where in a suit falling under subsection 1 and 2, the plaintiff or the defendant seeks cancellation of decree or other documents of the nature, okay, then separate fee shall be payable on the relief of cancel. अगर defendant इसके साथ cancellation भी मांग रहे हैं तो उस पे separate fee will be applicable. Next is 36 suits for joint possession. In a suit for joint possession of joint family property, दो लोगों को joint possession चाहिए property में, okay, then it will be the market value of the plaintiff share of the property. Simple. एडमिनिस्ट्रेशन सूट, अगर एडमिनिस्ट्रेशन को लेकर कोई सूट है तो उस केस में फी शैल बी लेविड ऑन द प्लेंट एट द रेट स्पेसिफाइड इन सेक्शन 45. ओके, दैट्स इट. सी एडमिनिस्ट्रेशन वाला आपको एग्जाम में नहीं आएगा. ओके, तो ये आप नहीं भी पढ़ो तो इट्स टोटली फाइन, बट सिंपल सेक्शन 45 के अकॉर्डिंग एडमिनिस्ट्रेशन का कैलकुलेट होगा. ओके, सो या यू कैन जस्ट स्किप दिस वन. एडमिनिस्ट्रेशन का एग्जाम में नहीं आता. कैंसिलेशन ऑफ डिक्री इज इंपॉर्टेंट, यहाँ से क्वेश्चन बनता है आपका. ओके, सूट्स फॉर कैंसिलेशन ऑफ डिक्री. See, wherever I have told you to mark important, please do mark it. Okay, they are actually very important. In a suit for cancellation of a decree for money or other property having a money value, okay, or other document which purports or operates to create, declare, assign, extinguish, whether in present or in future any right, fee shall be computed on the value of the subject matter of the suit. So basically, whenever it's cancellation of decree, a decree is already passed by court and the person wants to cancel the decree. Okay, you want to apply for cancellation of decree. तो जो मार्केट सब्जेक्ट मैटर की वैल्यू होगी, ओके, सपोज जो डिग्री पास हुई है वो 5,000 के लिए हुई, आप 5,000 का डिग्री कैंसिल करवाना चाहते हो तो उस 5,000 इज द सब्जेक्ट मैटर. ओके, सब्जेक्ट मैटर ऑफ सूट. तो अकॉर्डिंगली योर फी विल बी डिसाइडेड एंड सच वैल्यू शेल बी डीम्ड टू बी, वैल्यू अब कितना होगा, इफ द होल डिग्री और अदर डॉक्यूमेंट इज सॉट टू बी कैंसल्ड, the amount or value of the property for which decree was passed was the or other document was executed. So अगर आपको पूरा डिक्री कैंसिल करवाना, इफ यू वांट टू कैंसिल द होल डिक्री और डॉक्यूमेंट, ओके, इन दैट केस जो डॉक्यूमेंट एग्जीक्यूट हुआ था, ओके, द वैल्यू ऑफ प्रॉपर्टी फॉर विच द डिक्री वाज पास्ड और अदर डॉक्यूमेंट वर एग्जीक्यूटेड, तो जितनी सपोज आपको पूरी डिक्री कैंसिल करवानी, लेट्स टेक एन एग्जांपल, आपको एक पूरा डॉक्यूमेंट या पूरी डिक्री कैंसिल करवानी, तो पूरी प्रॉपर्टी की वैल्यू या पूरे उस डॉक्यूमेंट की वैल्यू आपको उसके अकॉर्डिंग फी पे करना होगा. बट सपोज इफ यू वांट टू ओनली कैंसिल अ पार्ट ऑफ डिक्री और पार्ट ऑफ डॉक्यूमेंट, इन दैट केस जितना पार्ट आप कैंसिल करवाना चाहते हो उतने पार्ट की वैल्यू का आपको फी पे करना होगा. Okay, so in case of cancellation of decree, if you want to cancel it as a whole, pay the fee for the according to the whole value of the property. But if you want to cancel in part, pay fee according to part of the property. Okay, subsection 2 is again important. It says if the decree or other document is such that the liability under it cannot be split up and the relief claim relates to only a particular item of property. Okay, suppose this is a property. Plaintiff सिर्फ there are two owners of the property A and B. अब B सिर्फ अपनी वैल्यू तक का रिलीफ मांगना चाहता है, बट वी कैन नॉट डिटरमाइन द वैल्यू ऑफ B. हम नहीं कैलकुलेट कर सकते कि B की वैल्यू कितनी है. In that case, the fee shall be computed on the value of such property or share or an amount of decree whichever is less. तो जो प्रॉपर्टी की वैल्यू है या फिर जितना आप अपना अमाउंट क्लेम कर रहे हो डिक्री में, दोनों में से जो लेस है, ओके, उस पर आपका अमाउंट डिसाइड होगा. ओके, सो इफ इट कैन नॉट बी स्प्लिट अप, अगर वो आप suppose it's a whole property and you cannot split up your part and you want relief for only your part but you cannot split up, आप डिटरमाइन नहीं कर सकते वैल्यू ऑफ योर पार्ट. इन दैट केस ईदर द होल अमाउंट ऑफ प्रॉपर्टी और द वैल्यू विच यू आर क्लेमिंग, ओके, जितना आप अमाउंट क्लेम कर रहे हो, उन दोनों में से विच एवर इज लेस, फी विल बी डिसाइडेड ऑन दैट वैल्यू. देन कम्स suits to set aside attachment. Okay, see, there are a lot of sections for this purpose. So what we will do is we will do this. See, one half we have done. Okay, first half we have done. There are total like 74 sections. So first half is already completed. 38 sections are already done. Remaining from 39 to 74, I think let's do it tomorrow. Okay, because it's getting too much for you guys to understand. So what you can do is from 1 to 38. Okay, wherever there is these things, just make a table out of it. Okay, it's your today's task to make a table out of all these sections. कि section number आप मत लिखो, it is not important. What you can simply write is what is the value of the property, okay, what is the value of property, and in which type of suit it will be according to value, in which type of suit it will be according to plaintiff's right, okay, and which type of suit it is according to the relief claimed. ये तीनों को आप डिवाइड कर दो. अब कैसे डिवाइड करोगे? इंडिविजुअली मत लिखो. ओके, डोंट राइट इट इंडिविजुअली दैट फॉर दिस सूट दिस इज द वैल्यू. जस्ट राइट इट इन होल. मेक 3 columns. Okay, 1 column relief sought, okay, or valuation according to relief sought. Second, valuation according to plaintiff share, and third, valuation according to market value. And उसमें आप लिखते जाओ कि relief sought में कौन कौन से पॉइंट्स है, plaintiff के relief plaintiff के शेयर के अंदर कौन कौन सी चीजें आ रही है, और मार्केट वैल्यू में क्या क्या चीजें आ रही है. Okay, this will help you a lot. So write your things like this. Okay, and 20 rupees, 30 rupees, you can just write it next to that. Suppose आपने 3 columns बना दिए. Let's say you have made 3 columns. First is relief sought, okay, plaintiff share, and third is market value. अब आप इसमें लिख दो दिस इज फॉर डिक्लेरेशन. अगर इसका डिक्लेरेशन होता है तो रिलीफ सॉट, अगर इसका इंजंक्शन होता है तो रिलीफ सॉट, ये होता है तो मार्केट वैल्यू. एंड उसके पास लिख दो और 30 रुपीज और 20 रुपीज, maximum 30, maximum 20, like this. Just make it, okay, just make a table from section 1 to 38. It will help you a lot in your exam. Okay, I'm like pretty much sure it will help you a lot. मैम आपका कोई टेलीग्राम हैंडल नहीं है क्या? अक्षिता, लाइक टेलीग्राम हैंडल नहीं है, या it's not there. But if you want, you can mail me. If there is any query, you can mail me at my like ID, official ID. So I'll just give you my official ID if you want to contact for anything. Okay, so it's Sakshi Ara @Lawsikho.in. Okay, so if you want to contact me for anything, this is my official mail ID. You can just ping me there, right? But yeah, it's an easy trick to remember all these things. Just make 3 charts: 1 for relief sought, 1 for plaintiff's share, and third for market value. एंड उसमें लिख दो रिलीफ सॉर्ट में क्या आ रहा है, प्लेंटिफ के शेयर में क्या आ रहा है, मार्केट वैल्यू में क्या आ रहा है, एंड 30-20 रुपीज जो भी है वो पास पास उनके लिख दो, तो इट विल हेल्प यू अलॉट. सो नाउ 1 to 38 यू कैन डेफिनेटली डू दैट, राइट. ओनली 38 सेक्शंस आर देयर, सो इट्स इजी फॉर यू टू कवर अप इन वन सेक्शन. तो आप उसको आज 1 to 38 कर दो, कल हम रिमेनिंग को कवर कर लेंगे. Alright, so yeah, that's it for today. If you have any query, you can ask me, or then let's conclude the things. Okay, so I think everything is clear so far. Then thank you so much, guys. That's it for today. We will again meet tomorrow and complete this particular act. Okay.